Hang on, it's preparing the stream.
There's a delay.
Hope I haven't cut everybody off. We'll find out in a second.
So they'll see 15-second delay to what's happening now. What they see on the screen.
All right, if y'all can hear me, just be patient. I'm streaming the YouTube as we speak. Free 2 weeks now. Zoom. Give me 10 seconds. I'm checking to see if I'm getting 2 audio feeds. Please no one speak. Okay. All right. Back. And of course I am.
Like everybody can see you on the screen.
Right, I'm going back. It's an audio issue now.
Yeah, I'm not hearing any audio on my computer, but I don't normally anyway on the speakers.
We'll find out if it works. Okay, guys. All right. Good afternoon again. This is Judge Kazen. I've called the case. I was taking announcements. David, I believe you were first.
Yes, Your Honor. David Johnson and Annika Kranye for Professor Laura Burney, plaintiff in this case.
And good afternoon, Your Honor. Blake Stribling, along with my partner, Lauren Balcanar. We represent defendant St. Mary's University, along with Bob Newman, who's also present.
All right.
And also with us, Judge, is by far the most important member of this team, our paralegal, Jamie Stafford, who's agreed to put up with us at least for another afternoon and will be helping with our presentation today.
Okay. Anyone else?
Your Honor, this is Daniel Ciano from the law firm of Tinsman and Ciano. I'm here on behalf of Ms. Burney as local counsel. I've not entered a formal appearance. Like Mr. Newman, I will say very little today.
Was that a hint to Mr. Newman?
No, he already invited it. I accept it.
Mr. Ciano's already said more than I said.
Yeah, I knew he couldn't stop. He had to follow up.
All right, Mr. Newman, I've got you here. All right, anyone else?
Your Honor, Mary Henderson here on behalf of the Office of the Attorney General. We have not entered an appearance. We've been provided notice of this proceeding pursuant to Property Code 123.
Okay, all right. So it's your motion. You may proceed.
Well, Your Honor, there's 2 motions. There's
Correct.
counter motion for summary judgment. Would you like for plaintiff to start since we have the burden of proof?
I would, please.
Okay. And Your Honor, I would ask, I hate to strain the court's and my technology skills, but if we could screen share, I do have a PowerPoint I'd like to put up.
All right, I'm not sure how to do that, but we'll try. So anybody there a whiz on screen sharing here?
We may be able to. Jamie, can we help him out?
Yes. Your Honor, if I may.
You may.
At the bottom of your screen, there should be a green button titled Share Screen.
Correct.
Then you should be able to select the button that lets us have access to it, like a share or an advanced setting.
So I've clicked it open. There's a window that says share. I'm going to click share.
So we can see your screen, Your Honor. There should be another button that says advanced settings, or I apologize, it doesn't show me this exact language for that option.
We'll go backwards. Let me stop share,
Yes, sir.
go back to screen share.
Yes, there should be like a little down, like an arrow next to the share screen option.
It says share screen, basic and advanced.
Hit advanced, please.
I've got advanced.
And what are the options there?
PowerPoint virtual background, portion of screen, music on computer sound, and control from second camera.
Are you the host of the meeting, sir?
I am, yes.
You should be allowing.
All right, so I'm gonna, my thought is that it's only going to allow what I put on there, not necessarily what you put on there. All right, so I'm gonna click share in the advanced options. Did that work for you?
Your Honor,
Yes.
this is Dan Ciano. I have my IT specialist, Michael Gonzalez here. He indicated that you would have to make Mr. Johnson a co-host. And how does he do that, Michael, so he can do that?
Your Honor, what you need to do, there should be three little button on the right, top right-hand corner of whoever the person is you want to make co-host so they can share. What you'll need to do is click on that little button. It should have like 3 little dots in it. Click on that and it should say on there, make co-host.
All right, David, you are now co-host.
Your Honor, if I may just briefly be heard, I would note there's competing motions for summary judgment here today.
I understand. I lost my reporter. Hold on.
Certainly.
It's getting ridiculous. Hold on a second. Yes. You are kidding me. All right, we'll see if you can get back on. Let me know. That's fine. The other option is, because I never panic into stuff like this, I'll put you on speakerphone and you can take it that way if the internet's down. All right, hold on. It'll all work out. All right, so at least we have this resolved. We've got a share screen. We're making progress. And just as we made progress, my court reporter, who is doing remote because I'm trying to keep as much staff away from here as possible, her internet went down. So she's going to see if she can get back in. And we'll go from there.
So Judge, you can see my PowerPoint now?
Yes, I can.
Great. And just let me know whenever you would like for me to begin.
Sure.
I can do it on my phone. Cheryl can use her phone to click on the link. and
Right.
participate.
No, she doesn't have internet. Her internet went down.
But like if her data plan.
Wait, I think I just see her.
My data plan on my phone. She might not either.
Yeah. So I'm going to call her and let's see if we can get this. Ben, can you hook up this speaker thing? All right, at this point, this is where a wise and prudent jurist says, you all lose. Yeah, I'm gonna set up, Ben, that speaker. Oh, you want to put that speaker? I'm gonna set up the speakerphone and you can just hear it through the audio and see if that works for you, okay? All right, then I'm gonna call you in just a few seconds, all right? Let me give you her number. It's 385. 210? Yeah, 210, 385. Yeah. I want to broadcast it to the world either. I have it on. 385-76.
Hey, this is Cheryl. Leave me a message and I'll call you back. Thanks.
Of course that would happen.
Record your message when you are.
Turn up the speaker.
Yes, sir.
All right, let's see if this works. If it becomes troublesome for you, it just is what it is, and we'll have to continue the hearing at another time. Fortunately, there's not, as I understand it, although this is a very important matter, there's not an emergency aspect to it. Okay, we'll continue now. All right, Mr. Johnson, I believe you were just about to start your presentation. We had enabled the share screen, and you may begin.
Thank you, Your Honor. So, like I said before, Ms. Cronje and I represent Professor Laura Burney. This case is a case dealing with a restricted fund, an endowment at the St. Mary's University. And I don't know to what extent Your Honor's read the motions and whatnot. So let's just kind of start with some big picture things, because I don't know that judges probably hear a lot of litigation with regard to endowment funds. There's first of all, restricted funds given to a charitable entity like a university create a fiduciary relationship. And that's when a donor says, I'm going to give you these funds, but on these conditions. You can only use these funds if you're going to use them with these conditions attached to them. And under the Texas Property Code, that would be defined as a charitable trust, and the Texas Trust Code applies to it, other than the Principal and Income Act and the Prudent Investor Act. But the rest of the trust code would apply because it's a charitable trust. The manager of the funds, in this case it'd be St. Mary's University, is the trustee of the charitable trust and owes fiduciary duties to make sure that they comply with the terms of the gift. In other words, the terms of the trust instrument. Those duties include the duty of loyalty and the duty of obedience to follow the restrictions set forth by the donor. If the trustee violates the donor's instructions, it's breached its fiduciary duty, and it can be held responsible at law. And so I think, a lot of what the university has put in their papers really doesn't really acknowledge the fact that it's standing in the position of a fiduciary. And as Your Honor knows, that's a very high position. Fiduciary duties, the highest duties known to law. And people that take on those duties have a very high standard to live up to. And it's a voluntary position. The university could have said, no, we don't want your money. And then therefore it would not be in a position of having to properly manage those funds and distribute them. But if you take on that position, you do take on these fiduciary responsibilities. So Professor Burney is the current Castleberry chair, has brought claims against the university due to its mismanagement of a charitable trust known as the Castleberry Endowment. The Castleberry Endowment was created through an inter vivos gift by Frank Scanio Jr., one in 1985 and a second letter in 2003. Those are the gift documents. If you will, that's the trust document that provides the terms that the university accepted when it accepted the money. The university is the trustee of the trust and owes fiduciary duties to its beneficiaries. One of those beneficiaries is, of course, my client, Laura Burney, who is the chair of the Castleberry Chair Endowment. The Trust Code applies to what the university does and can do and should do with regard to those funds. The original trust document had a very specific limitation as to what the funds were supposed to be used for. And it states, the corpus of the gift shall be invested in a manner consistent with the preservation of principal and the generation of annual income, which said annual income shall be devoted solely and exclusively for the purpose of paying a senior professor teaching oil and gas law at the School of the Law of St. Mary's, a supplemental salary over and above and in addition to the salary normally budgeted to be paid to such professor in the School of Law for the express purpose and intent that the income from the endowed professorship shall be paid to such professor without any diminution whatsoever for the normal budgeted salary, which the professor would receive in the absence of the supplemental salary for the endowed professorship. Now, I know that's a lot to read, and I apologize, but it's very clear that Mr. Scanio Jr. wanted this fund to create income to be provided to the chair of his endowment as a supplemental salary. It's the university is going to pay him whatever they would normally pay them, and this would only be put on top of that. If the university didn't want to do that, they didn't have to accept the gift. The gift document specifically defines a class of beneficiaries for whom the gift is intended. It's intended for a full-time professor actively teaching oil and gas law, and either a senior in years of service teaching oil and gas law for the School of Law, or a visiting professor of national reputation in the field of oil and gas law. So that's a kind of specific position that benefits from this endowment. And the reason I bring that up is because a lot of the university's briefing, it's like ships passing in the night. They set up a straw man and argue 90% of their motion on something that we don't even argue about. And then the 10% of just the heart of the case, they don't even really talk about other than to say that, oh, Professor Bernie doesn't have standing. I'm not saying we did it right. We're just saying you can't complain about it. And so that's the reason I'm going through who is supposed to get this endowment. It's supposed to be a full-time oil and gas professor, which Professor Bernie has been, and when she was specifically named the chair. And so she has a very special connection to this endowment. The university has been using these Castleberry funds contrary to donor intent. The university has been diverting trust funds and applying its endowment by granting itself discretion, and they use the word discretion a million times in their briefing, to manage the funds. We don't disagree that they have some discretion, but it's what they have discretion to do is what we have a problem with. First of all, the word discretion does not appear anywhere in the gift documents that create the Castleberry endowment. Nowhere does it state the university has discretion to say how much income to distribute. You have discretion to keep some of the income. You have discretion to actually pay yourself the income or to reimburse yourself or to lower your expenses. The gift documents do not allow for the application of the endowment policy. And that gets into the fact that the university has created a university-wide, endowment-wide policy for how they're going to use restricted funds. Under the policy, the university is permitted, now this is the university's policy that they just sua sponte created, and doesn't have anything to do with the actual terms of the restricted gifts, right? This is just something that a committee gets together and writes up a policy. And the policy says they're going to use at least 50% from endowed funding for existing salary and benefits. So if a professor has a budgeted salary of $100,000, they're going to, and there's an endowment that pays them $100,000 of income a year, 50% of their salary will come from the endowed funds. So the university only has to pay $50,000 out of its operating budget. And it says at least 50%. So they could choose to do 70%, 80%, or 100% of the professor's budgeted salary coming out of these endowed restricted funds. Secondly, they say they can make an allocation to the professor of up to 25% as essentially a supplement to their budgeted income. So that means that up to means they could have zero supplemental salary coming from endowed funds, or it could be up to 25%. And thirdly, it says making an allocation to the professor of up to 25% for professors' travel, research, and continuing education. So the university can keep essentially 75% of the annual income from the Castleberry Fund for itself. and allocate only 25% to Professor Burney. Obviously, the Castleberry gift documents do not allow that whatsoever. And the summary judgment evidence shows that they were doing this to the Castleberry Fund before Professor Burney became became the chair, and also after she became the chair, and did it up until the time that we caught them. And then it took them about 6 months to kind of fess up. And that was in June of 2020. They fessed up and said, yeah, you're right. We were doing it wrong. We'll pay you the extra 60 grand that we held back from you. And then after we sued them, they've apparently now taken another twist. And they said, well, when we admitted we did it wrong in June, we take that back. We weren't doing it wrong. We really have discretion to do whatever we want to with this money. Well, let's go back and look at the various different swing. Yes, Judge?
Let me pause, because that's a good point, pausing point, to check in with my court reporter. Cheryl, is this working for you?
Yeah, I can hear him. I think my internet just came back up.
Yeah, we can do both. Just don't disconnect my phone.
Okay, I'm not going to disconnect. Let me try to get back on.
Would you like me to wait, Your Honor?
Yes, please. That's why I said it's a good time to pause.
Yeah.
Okay, I'm going to try to bring the Zoom back up. Hold on.
That's all right. I'll wait. And there you are, and I'm admitting you again. All right, so Cheryl, because you've now probably got 2 microphones, are you getting an echo?
No, I'm not.
All right, so I'm gonna mute you over here on this one. And I'm gonna we'll hang up on this one.
Okay.
And if we are disconnected, text me immediately so I can keep everybody from having to say it twice.
Well, I'm so sorry.
Yes. You're in so much trouble. I'm so angry. Look at the anger on my face. Yes. So it'll work out, man. You know me, I don't panic about stuff. All right, let's
Thank you, Your Honor. And
let me also, just as a courtesy to you, apologize and thank you for letting me do that.
oh, well, of course. These are interesting days we live in. I appreciate the court making this technology available for us. It's fantastic. So, getting back to the evidence, the kind of the swings that the university takes as to what they're going to do. This is Exhibit C8 from our response to their summary judgment. And we have actually 3 different internal memoranda that were prepared in 2017. So about 3 years before Professor Burney caught them in their misappropriation of trust funds. In this 2017 internal memoranda, university officials basically admitted that they should not be using this policy, this spending policy that we went through, the 50-25-25 policy, to the Castleberry chair. And it says, in 2016, I've been told twice by finance personnel that the new spending rules for endowments did not apply to new appointments to the law chairs. I believe in 16 that I've been instructed that chairs and professorships are to be administered strictly according to the donor's intent. And the letter says, in 16, I've been told twice by finance personnel that the new spending rules for endowments did not apply to the new appointments of the law chairs, because I believe that they're being administered strictly according to the donor's intent. So what in 17, the people in the finance office knew these are trust relationships. There are restrictions. You can't have this policy that we create give you authority to do what's different than what the restrictions are in the trust documents, because donor's intent is what controls. Then you fast forward to 2019, and you may see in our documents and in our evidence the name Professor Mingler come up a good bit. I'm sorry, President Mingler. President Mingler is the president of St. Mary's University. And apparently he is very concerned about budgeting and about the use of restricted funds. In 2019, he sent an email to the law school deans stating that just as a friendly reminder, I will look forward on October 1st to your written report on how you plan to spend restricted accounts that are within your jurisdiction to offset operational expenses this fiscal year. So he wasn't saying, please look at the endowment documents and see if it would be appropriate. Please give me your opinion as to whether we could. He's saying, I'm looking forward to you telling me how you're going to spend restricted funds to offset the university's operational expenses. That's a shocking statement. It's a statement saying we don't care about the restrictions for restricted funds. You're going to take money, endowed money, and essentially use it to offset our expenses. That is what you call a self-interested transaction in the fiduciary context. It shifts the burden of proof to the fiduciary to prove that what they did was correct. It's also presumed to be done with undue influence. It's presumed to be done with fraud. It's presumed to be void and invalid. In a subsequent meeting, President Mingler then tells the law school deans that at a minimum, there's over $500,000 that could be, quote, exploited by the law school for general operational expenses. In March of 2020, someone had asked a law school official to do an independent investigation into the use of these law school funds, including the Castleberry endowment, pursuant to this new policy, the spending policy that the university sua sponte created, the 50-25-25. And I would like to state that we have this memorandum, which we have attached as Exhibit C12 to our response to summary judgment. We did not get it from the university. It would be responsive to our discovery requests, but it wasn't produced by them. And I don't know that there are lawyers that are on the phone today have even seen it until probably we filed it. But in any event, here you have a law school representative who has done an investigation into looking into our endowment document, looking into the spending policy, and he says he is concerned with the university's endowed chair and professorship policy, how that policy is being interpreted and applied, and the legal ramifications to that interpretation and application. He says it is possible that the university may not be fulfilling its legal obligations with respect to how it is treating restricted accounts. And I am concerned that this may create risk of liability to the university and its directors. He goes on to state, the Castleberry chair is an example of my second concern mentioned above as it relates to the policy. The relevant language of the Castleberry states, and we've already read through it, right, that solely and exclusively should be used as supplemental salary over your budgeted salary. And he goes on to state, it appears to me that the university, pursuant to the policy and the standard internal procedure, is allocating up to half of the income from restricted accounts associated with chairs and professorships, and is instructing designees of chairs and professorships that up to 25% of the income restricted accounts must be utilized for travel and professional development. So that concerned him that they were using the scope of this policy to these restricted funds. Like the funds discussed above, I think there are legal issues associated with the policy and in the way the chairs and professorships are being awarded. In conclusion, it says, regarding these issues that arise from the fact that several accounts, and there were he was looking at 3 different endowments for the law school only, and he says there were lots of other ones he didn't look at. He says in the Castleberry chair, these 3 are restricted. It is my understanding that if a donor specifies that a gift is only to be used in a particular way, those funds cannot be used in a different way, whether by directly taking the funds, by directing them to other accounts, by claiming that unused funds ultimately be claimed by the university, or by allowing the unused portion to be carried forward. Further, when the organization, such as the university, accepts a restricted gift, my research indicates that the restriction is legally binding on the charity. That's from the case law and from statutes. So given that, and considering the direction of President Mingler's email, which we discussed, saying, I look forward to hearing how you're going to take money from the endowments for operational expenses, he says that he would recommend that the university undertake an accounting of all chairs and professorships over 5 years to determine if it has met its legal obligations with respect to those restricted funds. He recommends the university hire outside counsel to review each and every document to see if it has been violated by the university's policy. He says, I realize that this is a significant undertaking, but I think there is significant exposure to the university and that it should immediately and decisively to avoid the kinds of claims and liabilities that could spin out of this. So this was once again an employee of the university who had been asked to independently look at this and provide his advice to his superiors. This was in March of 2020. After 2017, we had already seen these internal memoranda saying that it would be inappropriate to use this policy to the Castleberry chair. So what did the university immediately do that? Did they hire counsel to go through all those documents and see? I don't know yet. Have they done an accounting like he recommended of all of the restricted funds for a 5-year period to see if they were in compliance with the trust documents? I don't know. We've asked for that kind of information and it hasn't been provided, so we assume that they have not. We know that it took us till June of 2020 for the school to actually fess up to the fact that they'd been misapplying the Castleberry chair's funds, and that when we only paid you $16,000 in 1919, you're actually entitled to over $70,000. So we shorted you $62,000 for that year because we had used funds inappropriately. That's what they admitted in June of 2020. In their response to interrogatory number 6, this is the university's sworn response, and we asked them, tell us what you've been using these funds for. And they say, based on information and belief, that we did use our Castleberry Fund income to pay a professor's base salary for 3 years. And we used funds to pay a different professor for a completely different chair or different professorship. And that was a mistake, and we've already paid that back. So we know they breached their fiduciary duty. I mean, they've admitted that. They've admitted it in footnotes. They've admitted it in their interrogatories. What we don't know is how much they've breached their fiduciary duty. We don't know the scope of it. And that's what part of our case is going to entail next, is asking the court to order an audit, but that's not for today. So in 19, Professor Burney reviewed the gift documents for the first time. She determined the university was misapplying the endowment funds by using this policy. In June 20, Professor Burney received an email from this new dean of the law school admitting the policy didn't apply and determined that she'd been significantly underpaid. And also in the email, she said President Mingler had received a, quote, oral agreement from the benefactor's son, Frank Scanio III, to allow the university to apply its policy going forward. What we later found out is that just wasn't true, that Mr. Scanio never orally agreed to that, and that President Mingler was lying when he said that. Just a few months ago, the university admitted that the endowment policy didn't apply to the Castleberry endowment. The university now backtracks and takes the position that the claims that we've asserted are wrong and that it has discretion to apply the endowment policy to divert funds. So that's why we brought claims for breach of fiduciary duty, declaratory judgment to help us to define what these restrictions are, breach of contract, equitable accounting, and fraud. We have 4 fairly reasonable requests for declaratory relief. The first is the terms of the endowment dictate that the chair is the only one entitled to income from the fund. You can't keep income for yourself. You can't pay for other operational expenses. You have to give it to the chair. University does not have discretion either under the gift documents or under the Texas Uniform Prudent Management and Institutional Funds Act, which we all kind of call UPMIFA, to limit the amount of income it distributes to the Castleberry endowment, to the Castleberry chair, or to use any of that income for other purposes. The terms of the Castleberry endowment do not permit the university to retain any of the funds for itself, to divert the funds to the undergraduate program, or to use the funds to offset operational expenses like the regular budgeted salary for the professor. And secondly, the terms in the endowment do not permit the university to name a part-time professor as the Castleberry chair. So those are the four things. Those come straight out of the documents that create this endowment. Obviously, Your Honor, before you rule in these motions, we would like for you to actually read those documents, and I'm sure you will, because I mean, they're pretty straightforward. I interpret a lot of fairly ambiguous documents as a trust and estates lawyer. This one's really, really clear. You solely and expressly only allowed to use income for supplemental salary, period. The Castleberry Endowment, like I said, is an express trust. It's a charitable trust. The trust code applies. The court may intervene in the administration of the trust to the extent of the court's jurisdiction is invoked by an interested person under the trust code. And so is Professor Burney an interested person under the trust code? Well, yes, she's an interested person because she's a beneficiary of the endowment as the chair, as a named chair. She's the person, the only person who's entitled to receive any of the money while she is the chair. If they say that she's not a beneficiary, okay, if she's not a beneficiary, she's at least a other person having an interest in or a claim against the trust or any person who is affected by the administration of the trust. It directly impacts her salary. You can't say that she's not impacted by the administration of this charitable trust. And, I'm sorry I'm spending the time going through standing. It seems very plain to me, but they filed a motion to dismiss our claims under, because of standing. And we had to file a lengthy response to that. And then they just dismissed the hearing. So they take standing very seriously for whatever reason. We think it's a bit frivolous, but under the Declaratory Judgments Act, of course, any party that's interested in a document can have a court come in and construe the document. I'm not going to read all this.
No, and Mr. Johnson, let me be very clear about this. I actually pride myself on reading the stuff you make me read. So this was quite a thick file, and I have spent some time going through all of it. But I don't hold it as against anyone to spend their time presenting their case as how they wish.
Okay.
It doesn't bother me at all. In fact, I might hear something I didn't think I already knew. So please. Well, but I've heard you mention it twice, that you're sorry you have to read it. Present your case as you wish to present your case. I'm fine with it. Okay.
Well, and if Your Honor doesn't have questions about something, just let me know and I'll skip through it.
Oh, trust me, if I have a question, you'll get it.
Great. And so, under the Declaratory Judgment Act, anyone who is interested in a declaration or is impacted by the declaration must be made a party to a declaratory judgments action. And so clearly, since Professor Burney is the only one who's entitled to any money from the endowment, she would be impacted by the fact that they're giving money to someone else, giving improper amounts, etc. And numerous courts have recognized that charitable trusts, that people who have special interests in a charitable trust have standing beyond the general public to bring cases. And so, I've spoken to other folks, and it's very common for people when you have lawsuits over charitable trust for the charity who doesn't want to be policed to say, well, you don't have standing to complain about that. And so the court system has said, well, no, if you have a special interest to that charity, to that fund, then we're going to allow you to have standing. And we have multiple cases cited, and I think we've incorporated it by reference, but our response to their motion to dismiss is lengthy discussion of this special interest standing principle for charitable trusts. And I would point to the Gray versus St. Matthew's Cathedral Endowment Fund. It was a fund set up to benefit a church. They had went to court to have the fund terminated. A parishioner intervened, and the defendant said, well, you don't have standing to intervene because you're just a member of the congregation. And the court said, first of all, kind of looking at the case law that had been generated up to that point in time, and said that if a person has a special or active interest in the trust that justifies standing to maintain the action, then it can have standing. And it says the rule enunciated by the above quoted authorities is consistent with the reasons underlying the general rule relating to public charitable trust, because the problems of identification of beneficiaries and the undue harassment are not present when the class of persons are to be benefited is small and easily identifiable group. So that gets to the argument of, well, we can't just let anyone come in and complain about a charitable trust. I mean, just any person in the public, that would be onerous, that would be problematic. The courts say, no, if there's an easily identifiable group that have a special interest, then they have standing. And the court then goes on to say in this case that this person who is just a member of the congregation does have standing to complain about this trust that benefits that congregation. And said it's not, the difference isn't, is he different than any other congregational member? The difference is he different from the public in general? And the court said, obviously, yes, he is. So here, for this reason, so we have three different reasons why we have standing in this case. First is under the trust code, second, the Declaratory Judgment Act, and third is we have a special interest under the common law in this charitable trust. Now, once again, because the university doesn't want to get to the merits of our fight, which is that you can't use these funds to pay for base salary, you can't pay them to a part-time professor. They say, well, you don't have, you can't bring a declaratory judgments claim because there's not a justiciable controversy. This is all theoretical, is what they say. And we've gone through in our reply brief that we filed today and shown where for each one of these categories, it's not theoretical. It is absolutely brought up in this case by evidence. And so, for example, the ability to have all of the income from the fund go to Professor Burney, they take the position they have discretion to provide some, all, or none of the income to my client in their motion for summary judgment. And I guess I'm a little confused because I guess they say they have standing to ask for a declaration in their summary judgment. It's apparently justiciable enough for them, but it's not justiciable enough for my client, who's the one who would be getting the money. So it doesn't make a lot of sense to me, but that's their position. And I would just point out that, you know, we have taken opposite positions on this in our briefing. We say that, no, to the extent there's income, my client is entitled to it and no one else gets it. And you have to distribute it. The university also takes the position that it can limit the income as much as it wants to. And once again, we take the position that no, you have to distribute all of the income to my client. Now the issue becomes, what is the income? And that's one of the straw men that they bring up. They say they have discretion under UPMIFA to determine what the spend rate is. And we have attached an expert affidavit, which we would like the court to review. That is Exhibit D to our response to their summary judgment. And Mr. Moore, whose practices charitable institutional funds, that's his practice, goes through and explains UPMIFA and explains why, yes, the school has the ability under UPMIFA to make a determination of, quote, the spend rate. And so what that means is, historically, colleges, universities, any charities really had an issue because they would use trust terms for principal and income. And so, for example, income would be interest, rents, that kind of stuff, not capital gains. And so you had problems with investing because they would want to increase income. And so it would cause them problems in how they invested as between an income producing property or something that had growth. And so in the early 70s, all the way up through UPMIFA, becomes a trend of giving a charity the ability to set a spend rate so you can invest in growth properties. and allow the kind of income to include the capital gains and growth. We don't dispute that. The university has done that. They say is 4.75% is the spend rate for all of their endowments. They don't go through endowment by endowment and have different spend rates. It is a set spend rate for all of their endowments. And they said it's 4.75. We don't take issue with that. The issue is when you take our endowment, which in June they said it was 1.6 million. In October, they said it's 1.9 million. So we're not exactly sure what it is. We don't know if we gained $300,000 in 4 months or if they just lied to us in June or lying to us now. But in any effect, whatever that amount is, you take 4.75% of that. That is what you give to my client. You can't take it and use it for any other purpose. And you can only give it to my client as supplemental salary. They're saying they have discretion to take some money out of the 4.75, I guess, and use it for other reasons, to keep it, to roll it over. I don't know what all they want to do with it, but they don't have that authority. So that is why there is a justiciable controversy with regard to, you have to give us all of the income. How do you define income? Income is the 4.75% of the fund. So they spend 90% of their response to our summary judgment motion talking about their ability to set a spend rate. And we don't differ in that. We agree, you have the ability to set a spend rate. The issue is once you set the spend rate, you do not have discretion to monkey with it at that point. And you do not have, and so our third request for declaratory relief is that the university, that the Castleberry endowment does not permit the university to retain funds for itself, to divert funds to the undergraduate program, or to use any of the funds to offset its operational expenses. And we have evidence that they've done that. We have evidence that they have used the Castleberry funds to offset their operational expenses by paying the set base salary for the Castleberry chair. They've admitted that in their interrogatory. So to say that there's not a justiciable controversy is, I don't get it. I mean, and also they don't have the ability to, once again, 4.75%, we decide we're only going to give you 2% of that. We're going to keep 2% in the fund. We're going to take those 2% and give it to the undergrad. You know, we're not sure what they've done. And so discovery hasn't been done yet in this case. They haven't really produced discovery to us yet. So that's all going to be discovered. But they certainly have enough to get us to get a declaration as to what the documents mean under the law. And lastly, the terms of the endowment do not permit the university to name a part-time professor. The 2003 letter from Mr. Scanio specifically says that it has to be a full-time professor. And here, for a period of 5 years, I want to say, they paid Mr. Linton, Professor Linton, who was a part-time professor. He had 50% caseload. He only taught 2 classes a semester. And so, you know, they say, well, the university position it's kind of amazing to me at sometimes. They say, well, we call him a full-time professor. He only worked half-time, but we called him full-time. So since we called him full-time, then it counts. And you don't have a justiciable controversy. Well, there's the old saying, if it walks like a duck and it quacks like a duck, you know, it's not a dog. And so Professor Linton, who never published a law review article, who wasn't a national renowned oil and gas professor, was named the chair, and he worked part-time, and they paid for him his base salary out of our endowment. I mean, it breaches about everything the endowment documents say. And so we need to have that clarified, that no, it has to be a full-time professor. And full-time professor meaning that you take a full caseload. So clearly we have standing to pursue all of the relief that we've requested. And getting back to Professor Linton, this is from their own evidence. This is their exhibit 1. I can't read it. I think 1D or 1B. And it shows in 14 to 15, he had a 50% caseload, 15 to 16, 50% caseload. And you see his salary percentage, he was getting paid half of what he was getting paid. So he was a part-time professor. There is only one direct beneficiary of the trust, and that's my client. That is the only person that should be getting any money from this endowment. And she is entitled to 4.75% of the funds that should be in the account. See, that's something that I also say as well, that may have happened before you were chair. You don't have standing to complain about anything that happened before you were chair. That is also false because everything they did impacts the fund. If you pay someone inappropriately, if you self-deal and pay for your set salary that should have come from the university with funds, those funds should be put back into the endowment. You know, it's the old disgorgement of improper benefits. And then our 4.75% should be times whatever should be in that fund. So we go back to the beginning of time to see if what they have done wrong and to see what they have mismanaged and what they have improperly taken out and what they've improperly used. We put those funds back in, then we take 4.75%. That's what she gets for 19. That's what she gets for 2020. So that's why we have standing, and that's why she's directly impacted by all of their misfeasance. If the university has mismanaged funds before she was chair, then that impacts our supplemental salary. And they spend a lot of time talking about MIFA, which is fine. Once again, we said 90% of it we don't disagree with. They have the ability to set a spend rate. But MIFA, what it doesn't do is give them discretion to change the restrictions. And everything they have that talks about MIFA talks about the fact that donors' intent controls. Even the spend rate. If there was donor intent that says you have to set a spend rate of X%, that controls over at MIFA and the prudence standard. That is a set standard that is in the absence of donor intent. But it clearly at MIFA doesn't impact whether you use the word income, whether you use whatever you want to say. It doesn't impact how you spend the money, who you give the money to. You don't have discretion with regard to that. That's why I said there are two ships passing in the night. They talk about discretion. We talk about lack of discretion. It's because their discretion, we agree they have discretion for the spend rate, but they don't have discretion to hold back money, to give it to someone else, to use it improperly. And they're saying we have discretion to do all those things. Which is what this slide says. Once the university sets the spend rate and allocates funds as income, all income must be paid to my client. And that MIFA does not trump donor intent. I mean, if you look at chapter 163 of the property code, over and over and over, it prefaces it with, unless donor intent says otherwise, or in subject to donor intent. In our summary judgment motion, we asked the court to grant our summary judgment to look at the documents that create this Castleberry Chair endowment and to give us those 4 declarations that we've asked for, which are very reasonable and completely supported by the evidence and the law. Their summary judgment, which is a mirror opposite, which says that we don't have damages because they have discretion to not pay us the income from the endowment, should be denied in total because it's not supported by the law or the evidence. And with that, Your Honor, unless the court has questions for me, I'm sure you may have some questions at the end. I'll let opposing counsel respond.
I'll save my questions.
And I'll do my best to stop my screen share and give it back to you.
Well, now we got to go through 10 figuring out how to let somebody else use it. So hold on a second. Who's presenting next? I think it's you, Blake.
Yes, Your Honor. May I proceed?
And you're going to want, again, co-sponsorship.
Yes, Your Honor. For Miss Stafford, I think is going to drive on our side if that's okay with the court.
Yeah, let me see if I can find Miss Stafford. There she is. So I'm making her the co-host, I guess, then. All right.
We would appreciate that, Your Honor.
Yeah, through the years, I've always gotten a kick, and I don't mean this in a disparaging way, but I've always gotten a kick out of bench trials when people try to make their PowerPoints, pop and move. And I'm like, it's a bench trial, save it for the jury. I just want to see the info. So, all right, does that, now having said that, I bet here comes a pop-up presentation.
I think just the info, I think. May I proceed, Your Honor? So we just start by saying it's the first time Mr. Johnson and I've worked together. There were some whoppers in there. But let's try to unpack this. And I think the way we'd like to do it, Your Honor, is by resetting kind of where we are. As the court knows, each side's filed a motion for summary judgment. The university's motion for summary judgment is one, to get rid of Miss Burney's claim, Professor Burney's claims for damages in this case. Her damages that she seeks in this case are based on what she calls entitlement to, quote, all income under the Castleberry gift instruments. All income under the Castleberry gift instruments on an annual basis, she claims she's entitled to. And to us, Your Honor, what's important here is what does income mean under the Castleberry gift instruments is the question before the court. There is an answer to that. It is under Texas law. It is under a provision of Texas law that Mr. Johnson in his 30 some odd slides did not see fit to point out to the court. We will. What the motion and the discussion here today is not about, in our opinion, it's not about whether Professor Burney is qualified for the Castleberry chair position. Certainly she is. It's not about trying to make somebody look bad or embarrass them with a snippet of an email or a document, even though there was a fair amount of that, which unfortunately doesn't surprise us. And it's not about whether the university has regard for donor intent. We do. And with that, I'd like to have the next slide, please, Mr. Stafford. Keep coming on, please. Your Honor, this is a provision that we didn't see in the presentation that preceded us. And what this is that Texas Property Code provision that deals with, or that is one of the provisions that deals with an endowment like the one in this case, a gift instrument. And you'll notice right up front, it says subject to the intent of the donor, and it goes on from there. And so everybody in this case agrees, and St. Mary's certainly agrees, that the intent of the donor is paramount. There's been a lot said back and forth here, but I want to stop there because I think it's important to note that Mr. Johnson, I think, recognizes that both sides agree on that point. There is no dispute that donor intent is what's important. So let's look at what Mr. Scanio intended, the donor in this case, with respect to the Castleberry gift instruments. Mr. Stafford, if we could have the next slide, please, ma'am. So problem with what the presentation that preceded this one is that it used one paragraph out of the Castleberry gift instruments. You may remember Mr. Johnson read a passage that said, solely and exclusively, period. Supplemental salary, period. You know, the gift instruments in this case are not long, Your Honor. This is from a 2003 gift instrument. And Ms. Burney and Mr. Johnson have this. This is what Mr. Scanio said his intent was, which is paramount. The corpus or principle of the endowment shall never be invaded for any purpose whatsoever. And then he goes on to give some direction concerning use of income. And it says one purpose of that is certainly to pay a supplemental salary to the professor occupying the chair. No dispute with that. Reading on, it says the word and to pay the reasonable and necessary expenses incurred in attending institutes and conferences. We're going to come back to that later, but I would just note for the court that Mr. Johnson's got this provision, didn't show it to you for a reason. The next slide, please. Because Mr. Scanio directed in the Castleberry gift instruments that the principal stay intact and that only income be used, this provision that we're looking at is what Texas law says the university is to do to give effect to the donor's intent. This is Texas law right on point, and it tells the university that when a donor does exactly what Mr. Scandio did in the gift instruments here, in other words, say spend only out of income and keep that principle intact, here's what it means and here's what it does not mean. Item 1 is what it means. It means, and this is Texas law, it's not up to the university to make this up. This is the Texas legislature, and by the way, that of 48 other states did this. 49 states have this law. I think Pennsylvania is the outlier, and they may still be counting up there or whatever. But with respect to item 1, it says when that language is in a document, the donor means to create an endowment fund of permanent duration, unless language in the gift instrument limits the duration or purpose of the fund. That is what the Texas legislature has said is donor intent. Here's what donor intent is not when that language is used. And Your Honor, I'd respectfully submit that on this central question, where the parties have this basic disagreement, item 2 is fatal to Mr. Johnson's argument. Item 2 is what the Texas legislature says that language is not doing. The donor is not otherwise limiting the authority to appropriate or spend, for expenditure or accumulation under subsection A, which are the prudence standards that we'll talk about. All of Professor Bernie's arguments concerning all, quote, all income run headlong into item 2, and they fail under it. Next slide, please, Ms. Stafford. We heard about Mr. Moore, the expert lawyer that Professor Bernie's retained to come in with she sponsors this affidavit that goes on in her response to our motion, 20 some odd paragraphs. We'd be happy to talk to Mr. Moore in a conference room down the road if we need to in this case. But he agrees with us right there in paragraph 15. He says he reads Tup Nifa, that statute that we were looking at, the exact same way we do. And of course, that should be no surprise because it's the law. Next slide, please. The reason we included this, and Your Honor, I'm sorry that we've included a drafter's comment on the statute that we were just talking about. I think it's the first time I've done that in a hearing like this. The reason why, though, is that there seems to be a debate still about what that provision means. We think it means exactly what it says. And this comment here from the drafters is consistent with that. And it says that it's to give effect to donor intent. And again, that intent is to create an endowment of perpetual duration. Next slide, please. At the end of section C, which we looked at a moment ago, which speaks to what donor intent is with language like we have in the Castleberry instruments. The last provision of that says that language does not otherwise limit the authority for expenditure or accumulation under sub A. So looking at sub A, this is what guides the university in this case with respect to spend or accumulation decisions from the Castleberry endowment. In that regard, the standard is highlighted there in what was green when we started doing this. I hope it shows up that way. But what it says is it sets a standard of prudence. And Mr. Johnson importantly concedes all that is needed to dispose of both Professor Bernie's motion on the first 2 grounds and to grant the university's motion in full, which is he says, well, yes, it is so that the university has some discretion, but that doesn't matter. The university has a standard of prudence. Under the plain language of the Castleberry gift instruments, it is subject to a prudence standard right here under sub A with respect to expenditure or accumulation decisions. What Professor Bernie's arguing for in this case is a compelled minimum requirement to spend in her favor. She is saying that the university should have to spend more, and it should have to spend it every year, and that there's a required minimum compelled spend. Mr. Scanio did not set that in the gift instruments, and under Texas law, it does not exist. Rather, prudence is the standard that governs. Next slide, please. But it's not just prudence in the abstract, and the university has never said and is not taking the position that it somehow has unfettered discretion. Quite the opposite. There are statutory standards that the university follows that are set forth in Texas law. We've put them on the screen here. These considerations guide spending and accumulation decisions, and the university is bound to follow these considerations in making those kinds of decisions. Next slide, please. We've heard some from Mr. Johnson's presentation about the spend policy. Now here there's been some evolution in Professor Burney's positions relative to what she's entitled to. When this case started, she said she's entitled to all income from the Castleberry endowment, and she still has that claim. Now what they're saying is well, income means, all income means whatever the university's spend policy says. The problem with that, and by the way, under that statute we looked at, institutions like St. Mary's are expressly encouraged to have an investment policy. It's the responsible thing to do. It's the prudent thing to do. And the university does exactly that. The university sets a more conservative policy in terms of spending from an endowment than is allowed under the law, so more conservative. But Mr. Johnson told you earlier that the university says 4.75 from every endowment, every one of them, if you remember. But that's not the case at all. What the policy says is that the university is going to consider those factors that Texas law requires, and then it can distribute a percentage of, and this is going to be the next place where their argument fails as a matter of law, up to 4.75. By the way, the policy is set by St. Mary's. And so there's exercise of that prudence and discretion there that's fatal to their argument. And it says up to 4.75. It's not a fixed flat 4.75. Next slide, please. And we'll just briefly hit on this. Here again, with respect to the prudence standard, I don't think we should be surprised, but it is so that Professor Burney's own expert agrees with St. Mary's positions. And of course, because that's Texas law, they're those same factors. And this is his affidavit that he got under oath and swore to, and they submitted to the court. A through G right there, those same statutory factors. And you see highlighted about halfway down, he agrees that prudence is the standard, not the absolute rule Mr. Johnson's in here advocating for. That alone is fatal to their argument. Next slide, please. Here are just a sampling of the allegations, Your Honor, because I think it's important to bring it back to how we get here. And the way we get here is Professor Burney saying that she's entitled to all income, all of it, under the Castleberry gift instruments. We've seen how under Texas law, that's not the standard, not at all. But what we wanted to show the court briefly is it's not even right under the plain language of the gift instruments. This is not about Mr. Scanio's intent. We're going to see if we look at the gift instruments that this is Professor Burney's argument that has nothing to do with that intent. Let's look at the next slide, please. So this is the paragraph Mr. Johnson showed you earlier, a snippet of it, and he highlighted the exclusively and solely language. And he uses this to tell the court that the donor had specific intent here that all income on an annual basis be paid to the chair, all of it. And let's have the next slide. What he did not show the court was that the same document says this: in the event that accrued income for a fiscal year is not spent at the end of such fiscal year, it shall be added to the corpus. This is the donor contemplating that all income may not be spent at the end of the year. That happens, and that's what the property code's talking about when it says decisions to spend or accumulate. Next slide, please. And of course, we also talked about that they also didn't show the court that the donor expressly contemplated, apart from the supplemental salary use, using a portion of it to pay the reasonable and necessary expenses. Next slide, please. And again, under this provision of the property code, Professor Burney's argument fails as a matter of law because she is trying to use a reference to income, not all income. The gift instruments never say all income, by the way. They'd have shown it to you if they do. They don't say that. Only Professor Burney's papers say that. But because of what the gift instruments do say, what they do say, to give effect to that, we follow the property code, Texas law. And under this section C2, Professor Burney's arguments fail as a matter of law. And we would respectfully submit that we believe St. Mary's entitled to summary judgment for those reasons, and that their first two grounds should be denied. Jamie, let's go forward. Keep coming, please. So I think, that speaks to items 1 and 2 from our perspective in their motion, as well as St. Mary's grounds themselves. Would like to maybe a couple comments as to their 3rd and 4th grounds in their summary judgment. Jamie, come forward, please. Here are their 4 grounds, just to reset kind of where we are. Again, it would be the university's position, Your Honor, that with respect to both 1 and 2, the reasons that we just articulated, which we believe support entry of summary judgment in favor of the university on its motion, also dictate denial of their 1st and 2nd grounds. As to 3 and 4, a few comments, if we might. But first, as the court knows, because it is their motion for summary judgment on declaratory relief is what they want. And I think they embrace this in their papers, although they sort of walked away from it here. They don't really argue to their grounds. And that's what they're required to do. In their papers, they say, the documents unambiguously call for what we say. Mr. Johnson's argument here goes everywhere except to the language of the documents, and there's a reason why. And so when we're evaluating their summary judgment grounds, what those are tested against is whether they've shown the court that the documents unambiguously call for these things. Indeed, they do not. And so the 1st and 2nd grounds fail for the reasons we've articulated. Jamie, can you go forward, please? Keep coming. With respect to grounds 3 and 4, go ahead, Jamie. Here is where their standing challenge is in this case. They've not asked for declaratory relief that she has standing as an interested person. What our standing argument here is, and I'll just briefly hit on it, is 3 and 4 don't relate to how much money Professor Burney is entitled to. Those are disposed of under counts 1 and 2, which we believe they lose as a matter of law. Her own stated basis for standing is that her salary would be affected. Under 3 and 4, she seeks declarations unrelated to that. So that's our standing argument, and we don't think she clears her own hurdle. Next slide, please. As to the justiciable controversy points, we would just say this. The university unquestionably has acknowledged that it made some mistakes. Those mistakes were not during Professor Burney's term. The university is taking the appropriate steps to deal with those mistakes. Did not get, quote, caught by Mr. Johnson. And those mistakes did not impact Ms. Burney in any way. And unless she can convince the court that she's entitled to an absolute compelled minimum spend, as she now says, she doesn't have any argument whatsoever that those mistakes are anywhere relevant to her, other than, I guess they're helpful in this presentation to try to embarrass the university. But it does not give her a justiciable controversy. The university acknowledges that it can only use the money in the Castleberry endowment for the purposes, for the uses that were contemplated in the gift instruments. But that's not what this case is about. This case is about whether Ms. Burney is entitled to more money as the chair. Not what purposes are okay, but how much does she get? Jamie, come forward, please. And in this regard, they are asking for an improper advisory opinion into hypothetical application in different scenarios of what they argue is prohibited under the gift instruments. But they don't point to the language of the gift instruments. And in this case that we put on the screen here, I think is really instructive. What they'd like to do is say, well, assume with me a set of facts. I'm not going to prove it, but assume with me a set of facts. Would that violate the gift instruments? How about another set of facts? Might that? Entirely improper use of declaratory judgment proceeding. And where this really, I think, lands, Your Honor, is on this ground 3 that they talk about. Mr. Johnson said multiple times that it is acknowledged that the university applied the endowment policy, he calls it. So the sworn evidence is that did not happen when Ms. Burney was the chair. Indeed, it hasn't happened at all. Professor Burney speculates that it could have happened. It might have happened. It did not. She does not prove it did. Next slide, please. But more fundamentally, their ground 3 creates problems in a number of ways, but it fails on its face because it conflicts with the gift instruments. Again, their summary judgment motion what they got to do is come in here and show that the documents unambiguously, they got to shoulder that burden, unambiguously call for what they say. Next slide, please. Keep going. Keep going. So one part of ground three is they say that the university cannot retain funds. And this is this compelled spending requirement they want. I guess they're trying to get there another way. Mr. Scanio said in the gift instruments that if at the end of a fiscal year, there's accrued income that's not spent, put it back in the corpus. That's retaining the funds. And so on the face of the documents, their ground number three fails. Next slide, please, Amy. The same as to operational expenses. You know, here again, under the plain language of the gift instruments, the university can pay reasonable and necessary expenses incurred in attending institutes and conferences by the Castleberry chair out of the Castleberry funds. Mr. Hanna's affidavit, which is in the record, tells the court that St. Mary's expenses are operational expenses. And so ground number three fails under the plain language of the gift instruments for those reasons. Next slide, please. You know, as to ground four, Your Honor, we would submit that there is no evidence in the record because it just didn't happen, that the university has somehow, appointed a part-time professor as the Castleberry chair. They may not like that Professor Litton was the recipient of it. They seem to tarnish him here by, Mr. Johnson questioning whether he had written certain articles or whether he qualified, in terms of a national reputation. Listen, I guess if they want to litigate whether he was qualified or not, they should do it head on. But I don't think they'll take that position. He was qualified for the chair appointment and he received it. And he was a full-time professor. Next slide, please. One more. And he was a full-time professor under the summary judgment evidence, which is, you can see there, that's Exhibit 1D to our response. This is Lee Litton's employment agreement. I understand Mr. Johnson doesn't like it, but just because he says it ain't so doesn't make it not so. It is so. So Professor Litton was full-time. And so there's no justiciable controversy about a scenario where somehow there was a part-time professor appointed. Indeed, the university acknowledges that the document doesn't allow for part-time appointment. It just didn't happen. And so for those reasons, the university would respectfully submit that Professor Burney's motion should be denied and the university's granted.
Sure. Question as it relates to number four. So what makes a full-time professor and what makes a part-time professor? I mean, does workload qualify as the defining factor as to who is full-time and who is part-time? And I'm going to ask this in a hypothetical. So I want to bring a very famous name to my campus and hire them on a full-time basis, and they only have to appear once a year. What keeps me from doing that, if so?
So can you back up one slide, please, Jay? And so I think that the starting point for Your Honor's question is what do the gift instruments say on the point? And here the gift instruments, they don't say. They say actively teaching oil and gas. And so they don't provide more than that. Now, I would say this. At most, Professor Burney's own evidence presents a fact question about, I guess, about this, about what constitutes full-time. But the Castleberry gift instruments don't tell us any more than full-time professor actively teaching oil and gas. And if you come forward, Ms. Stafford. And then I think what you see is that, that's what Professor Litton was. And so there's no more instruction provided in the gift instruments, which are our, really our guide here. I think that the plaintiffs have different views of that, obviously. It's not exactly clear to me what their standard is, which I think speaks to the reasons why the declaratory relief is improper.
Well, I mean, you're St. Mary's. What's their standard for full-time versus part-time?
Yeah, so I think the university has.
St. Mary's define it by virtue of the amount of work they do. That's all I'm asking.
No, I think the university defines it. I think there's a general standard that may exist under policies, but I think the university defines it on a contractual basis, on a one-by-one basis with each professor. And with respect to Professor Litton, it is expressly contemplated that he would continue actively teaching oil and gas, and that he would be a member of the full-time member of the faculty. And so I think the only way to answer the question with respect to Professor Litton is by looking at the four corners of his employment agreement.
Okay.
May I briefly respond?
You may.
And I don't mean to cut you short if you have other questions, but at some point I would like to have 5 minutes just to rebut, if I can.
Yeah, I mean, as soon as, let me pause for a second and say, Mr. Stribling's not done with his presentation. I just interrupted him with a question.
I'm sorry, I thought he was.
I was going to turn it back to you in a moment, but I mean, if you want to interject at the minute, it doesn't bother me.
No, I'm sorry, Your Honor. I apologize. I thought Mr. Stribling was done, so I didn't know
He
he
was
was
just about to be done, and then I cut him off. But go ahead.
But I think this is as good a place as any. For the reasons we've outlined, we obviously would respectfully request that Ms. Burney's motion be denied and the university is granted. And with that, we'll stop the screen share and turn it back over.
All right. Back to you, Mr. Johnson.
Thank you, Your Honor.
Others, if they wish.
So I guess I touched a nerve, apparently. Mr. Stribling, I think he used my name more than my client or his own client's name in his presentation. And,
What you guys do.
I guess I had that effect on people. But, I would say that from a big picture, once again, we're two ships passing in the night, as I said earlier. He spent 90% of his presentation on stuff that we don't necessarily quibble with, which is what does UPMIFA do with regard to a university's ability to have appropriation for expenditure versus accumulation. We obviously, they read that much broader in the sense that they have the ability to say how much we're going to give and how much we're going to keep. But that's not really kind of the way it works. The way it works is you do have prudence standards and you have to set a spend rate. When I say that, there's a percentage, and the statute says that 7% is presumptively invalid. So, or above 7% is presumptively invalid. And you could do it, but you have to, I guess, rebut that presumption. So they do have to set a spend rate because, once again, their assets aren't making income. They're more growth oriented. So if we were just going to get the quote trust income from it, we'd get very little, which obviously isn't the intent of Mr. Scanio. If they were going to do a pure income type thing, then they would have to invest this in rental properties and stuff that produced interest and things that were income producing. If they were going to take the position that all we have are investments in growth, we don't have to make any income distributions to you, then that would violate UPMIFA and the settlor's intent. So the point I'm making is that they have set up to 4.75%. And to my knowledge, the only thing that I've seen is that they use this 4.75% as the standard rate. That's what they have in their memos. That's what they have in their internal documents. And to be honest, if they come forward now and drop Professor Burney down to 1%, then I think that would be in bad faith, and it would be done in retaliation of my client exercising her rights as a whistleblower to show that they're doing things inappropriately. They mentioned, I guess they just completely misconstrue our third and fourth points for declaratory relief. And I don't think there's, our request for declaratory relief doesn't mean King's X, they lose, we get a judgment. This is a motion for partial summary judgment. We're asking the court to review documents and make a decision on what they mean. Then we are doing and we'll continue to do discovery. Then we'll take the discovery and facts and apply that to the declarations the court makes to have our final result. The point being, for example, when it says that the document says it has to be for a full-time, full professor, the court can declare that. And then we'll have a fight as to whether Professor Linton was or was not a full-time professor. If he was, then they didn't violate the document. If he wasn't, then they did violate the document. So, but that doesn't impact the fact that the document says that the only person that can get money is the chair, and the chair has to be a full-time professor. So we're asking the court to rule it's a full-time professor. Similarly, the document says it can only be used as supplemental salary. It doesn't allow them any discretion to pay for any other reason, for base salary, to pay for themselves, to give to operational expenses. It doesn't say they can do that. So the court can declare that. And then we have the facts later that will show that they did or didn't comply with that and what the ramification and remedies are for it. I'm just asking the court to review the document and give the declarations that come straight from the documents. Opposing counsel seems to want to say that I have the burden to prove my entire case right now. And that's A, not legally correct, and B, I'm not here to do that. I'm asking the court to set the ground rules moving forward in this case. Second, there are several other things. And he kept, I love how he read from the, he says that I didn't quote the language from the documents. I put a slide up for your honor showing the language. So I did cite to the language of the gift documents. And whenever he read from the gift documents, he left out some very important language. He keeps pointing several times to the fact that the 2003 letter says that the funds can be used for supplemental salary and it can be used to pay for conferences. And then he stopped. One time he stopped at expenses. The next time it was expenses for conferences, then he stopped. But then you read the rest of it, it says for oil and gas conferences. And so once again, we're going to have to go through and do an accounting. Have they used these funds to pay for non-oil and gas related conferences? If they did, then they misapplied the funds. If they didn't, then they didn't. And he talks about in the event, and he says that they don't have to distribute all of the income to my client. The document expressly contemplates and says that if any income is not spent, it goes to principal. That is because what if there isn't a chair that year? Or what if the chair happens to die mid-year and doesn't get paid and they have some extra income at the end? If you look at the very next sentence of the document.
You agree that that very argument tells me it is a question of interpretation. That your very argument tells me it is a question of interpretation, doesn't it?
Yes, and we're asking the court to interpret the document. Okay. And so in that paragraph, when the donor is talking about that, the very next sentence is, and if you don't have an oil and gas professor anymore, then you use it for this other purpose. So the whole point of that sentence was a stopgap saying, if there isn't a chair that year, or if the chair dies, or there isn't an oil and gas professor, then you obviously roll it over, you don't spend it. And then as soon as you do get a chair, then you start spending it again for the chair. It doesn't mean that if you have a chair, that you don't then give all of the income to the chair. So, another thing that I want to address shortly, and I know I said that a couple of times and I probably am not doing it, is they seem to imply that Professor Burney is in this just kind of for the money. And they don't understand that the last two provisions, she doesn't have standing because it won't impact her salary. First of all, it does impact her salary if they're spending it the wrong way, like I said, and if they have, that money should go back in the fund and we get 4.75% of the fund. So if they've done, and they never addressed that argument, right? In 2015, if they spent money inappropriately, then the university has to put that money back in the endowment. So instead of 1.9 million, the endowment should be 2.3 million. And my client gets 4.75% of what should be in the endowment. So all of these breaches do financially impact my client, whether it's before she was a chair or while she was a chair. So they're just wrong on that. And they didn't address my argument. And secondly, my client's not in this just for the money. If she were in it just for the money, we would have settled it before we ever filed this lawsuit. She's in it for principle. She wants the school to do what's supposed to do, to live up to donor intent. She would love for the AG to get involved in this and make sure that the school is doing this for other endowments, for their undergrad, for other law school professors, that they're abusing these endowments and using it for improper purposes. Someone needs to be in charge of the school and make sure they're doing it right. Their own internal memoranda tells them they're doing it wrong and they keep doing it. And I mean, the evidence in this case is going to show some interesting facts I'm not going to go into today about employees that apparently leave because they can't take on the risk of misappropriating funds. So the point of today is just to look at the trust documents and for the court to construe them. And we would ask the court to do that. We have standing for all of the relief we've asked for. And we're fine with the court looking at the documents from the four corners and making a decision as to what the settlor's intent was. What happens from that, we'll deal with the evidence in this case. And so with that, we'd ask the court deny their motion and to grant our counter motion for summary judgment. Does Your Honor have any questions?
No, not yet. I mean, I'll be honest with you, I've gone through this. I've looked at all the motions and I've tried to get it through as much of the exhibits as I possibly could. You know, at some point, someone's going to have to answer to me what all the income means, because it certainly strikes me, and I say that rhetorically. Of course, you don't need to define law school definitions of income to me, but you know, at some point, it did strike me that we went from all the income should go to, well, but you know, maybe they have the discretion to set spending, and if they have the discretion to set spending, then it's all the income within the discretion to set spending, 4.75. And that did strike me when I read the original pleadings moving on through it to go, well, how do we go from all to all of 4.75 allegedly? Because I mean, the position does seem somewhat inconsistent. Because if you're willing to admit that there's per law, the ability to set a discretionary percentage, then obviously if the documents themselves say income, you know, one might argue that it's not all income, theoretically.
Well, and that gets back to 163.005A.
Yeah.
And opposing counsel and I just disagree.
But that's where I have the discretion to decide what was
right. And so
I get it.
Appropriation for expenditure, once you appropriate it, you have to distribute it. And if you look at our expert's affidavit, opposing counsel apparently loves my expert. He cited to him a bunch. We both agree with my expert. So once you read all of my expert's affidavit, and he'll support what I'm saying, that once you appropriate it for expenditure, you have to expend it. And what it doesn't give them the discretion to decide is who to give it to. You have to give it to my client as supplemental salary. You can't give it to yourself to reimburse for her base salary. And they did that to my client. My client only got $16,000 in 2019. Then they came back and said, because of this spending policy. I mean, that's actual dollars she got when she should have gotten 70. And then they came back and said, oops, sorry, yeah, you're entitled to another $60,000. So I mean, I guess they could have said, well, we didn't appropriate that for expenditure. And we're going to ask for that. I mean, did they have memos every year saying we're only appropriating this much for expenditure? Of course they didn't. They have a set 4.75%. That's what they appropriate for expenditure. As soon as they do that, it's income. You have to distribute it. They don't want that, apparently.
Now, let me pause on that note. Your response to that?
My response to that would be, first of all, the statute in Texas tells us what the words in the gift instruments mean. And those words mean to give effect to donor intent, to create that endowment of permanent duration. There's prudency standards under subsection A of the statute. Against those standards, the university is to make decisions. Any argument that tries to convert the word income, and now we all agree it doesn't say all income anywhere in the gift instruments, but to convert the word income in the gift instruments to a compelled spending requirement violates section 165.03 subsection C2, which expressly says that an argument like this, and by the way, the legislature in Texas said these words that we're talking about mean something and they don't mean something else. The argument we're hearing right now is just another version of exactly what the legislature said in C2 those words do not mean. They do not limit or otherwise, they do not otherwise limit that subsection A prudence. The other note I would make is nowhere in the statute does it say that there is a spending, that a university is required to create a spending rule. That it simply doesn't exist. It is part of their argument now, but it doesn't exist in the law.
Your Honor, may I briefly respond?
Please. I mean, this is, for all the rest of it, this is the heart of it right here.
Right. So it says appropriate for expenditure. I guess I could go look at Webster's and say, what does expenditure mean? It means to spend. So so the prudence standard he's talking about is setting that 4.75%. They could set it at, 3%. They could set it at 6%. I mean, depending upon the factors and those factors he's talking about. But once you set it at 4.75, that is the appropriate for expenditure part. And once you set that percentage, it's a done deal. You have to then expend it.
And I say this for the record. Why?
Because the statute says for expenditure, not for accumulation. You can't set 4.75 for expenditure and then take money back and accumulate it. It doesn't make any sense. And this is also, I agree with you, this is a very important part for the first ground for our declaratory relief, but it's completely not appropriate. It's not important for our third ground for declaratory relief, which is that they can somehow use the money to pay for her base salary or pay for some other professor's base salary.
We'll get to that in a minute. That part of the letter was, and we'll discuss it a little further. It was that part of the intent. I think one could argue is pretty specific. It was for supplemental, but we'll talk about that in a minute. I want to get past the why if we're not all income, why 4.75%, because it was set aside for expenditure, why that necessarily means that a university can't, after they set that amount, say, wait, hang on a second, too much, not enough.
Because
if they feel it's prudent.
Yeah, well, I mean,
if I get Mr. Stribling's argument,
the prudent issue is the 4.75%. If 4.75% is not prudent, they can set it at 4%.
Basically, both of you are in the chicken and egg argument at the moment. Which came first? So, Mr. Stribling?
Yes, Your Honor, just briefly. I was just going to note and I think this is pointed out, but the policy in question, first of all, says up to 4.75%. All of this argument assumes an absolute requirement that I think really speaks to the fundamental flaw in what Mr. Johnson's grasping at here, which is some way to find a mandatory rule within 165.03A, and it just doesn't exist, and it can't. We would submit.
All right.
Your Honor,
Yes, sir.
may I speak?
Mr. Newsom, you may.
Judge, the bottom line here is I understand Mr. Johnson's argument about 4.75. That's not responsive to our summary judgment, nor is it the basis of our summary judgment. Our summary judgment is pure and simple. The use of the word income does not establish any sort of an obligation to distribute all income. The statute says, a crystal clear Texas statute says, use of the word income establishes an intent to create a permanent endowment, and further, it does not limit the university's obligation to distribute or restrict its ability to accumulate. We wish to be judged, and we wish, if there are damages, to be paid under the proper legal standard. If Mr. Johnson has a different damage standard, then he should plead it. He has amended his pleadings twice. All we are asking for is a summary judgment that the use of the word income does not require us to calculate damages based on income. And the statute crystal clear says that. I cannot fathom how the court would try a case based upon using damages based on income, and how the court would charge a jury trying to calculate damages based on income when there is a Texas state statute directly on point that says this is all income means. Thank you.
I got it. I fully appreciate the arguments. I really do. I just had a question about the 4.75 and why that was okay. But anyway, anyone else want to pipe in before we proceed on to some other aspects of the motions for summary judgment? All right. And mind you, anyone can. I always find it useful when anyone who has standing to say something says something. Please don't take that as discouragement. All right. So You had a point to make, Mr. Johnson, as to the third request.
I was just going to say that no matter how you calculate income, our position is what was the percentage they used that year? You take that times the amount that should have been in the fund, and that's what my client was entitled to. My only understanding, the only evidence I've seen is that it was 4.75. Could they have altered that? I mean, they can't now. They can't go back in time and change it, but what was the percentage at the time? That's what we need to look at. But that is irrelevant for the purpose of, did they take money and use it for an improper purpose? In other words, did they use it for a base salary? I mean, the documents clearly say you can't use it for base salary.
And I'm going to pause there. I mean, and just not to put too fine a point on it. I mean, Mr. Stribling, that's what it says. So, I mean, what's the response to that?
With respect to, may the university use it for base salary?
Or other salary? Yeah. I mean, it pretty much says as a supplement.
So we agree with that.
It doesn't seem as though there's any question there. And if in fact the university had used it other than as a supplement, the university step up to the plate and go, yeah, that's what we owe.
So Your Honor, the university completely agrees that the allowable purposes, the uses of the Castleberry Endowment funds are those stated in the gift instruments. And so one of those is not to spend it on a base salary. What they are as follows, I believe. Supplemental salary, to pay for travel in conferences, expenses, the language we put up on the screen under the 2003 letter, item 5. And you can put it back in the principal, into the corpus, okay? And so the problem with ground number 3 in their summary judgment, we would respectfully submit in addition to some others, but let's get to the heart of it, is they don't ask for a declaration of what the gift instruments actually say as to the permissible purposes. They use their own language that is so vague and so broad that it actually contradicts the documents because it's unclear what they mean by it. The best example of this is operational expenses. They say you can't use it for operational expenses. Well, we know that under the gift instruments, you can use it to pay travel and conference, institute conference expenses. That is, if you look at the Hannah affidavit that we put in the record, that is an operational expense, what would otherwise be an operational expense. And so the issue with ground number 3, Your Honor, is not relative to the base salary point. It's that they don't simply track the gift instrument language. If they had, or if they'd sent us discovery and said, does St. Mary's admit that these are the only permissible purposes of Castleberry funds and use the language of the gift instruments? No problem. No problem. There's not a fight here about that. But they've not presented to the court properly, and the way they have presented it would create confusion and actually, the breadth of what they asked for and the vagueness of it is where the issue lies, and it's the reason we argue it should be denied. But no dispute as to the base salary point.
Okay.
It sounds like the terms of my third point is what I'm asking for the court to declare is the terms of the Castleberry Endowment do not permit the university to retain any of the funds for itself. I think that's clear from the document. It can't use the funds for itself. To divert funds for the undergraduate program, I think I'm hearing they don't have a problem with that. And then or to use any of the funds to offset its operational expenses. It sounds like I hear that they don't disagree with that, except that they can use for travel and conferences for oil and gas conferences, which is what the document says. And if I added that one except clause in there, they'd be okay with it.
May I be heard here?
Yes, please.
So what I would say again is if they would like to use the language of the gift instruments, then that would be proper. So so we just saw the problem again. When he says divert funds, it is unclear to us because it's not what the gift instruments say. When we use the permissible purpose of retaining funds in the corpus, making that accumulation decision, it is unclear whether that would violate their third ground as stated with respect to that part. So if they would frame it in terms of the actual language of the gift instruments, no problem here.
All right.
I don't understand that. How would retaining I don't think they can retain funds if they've appropriated it for expenditure. That's the whole word the expenditure means. But in any event, if they did, let's say the professor died halfway through and there wasn't a professor and they retained that income for the endowment, how would that go to the undergrad? I don't understand how he has any heartburn over you can't divert funds for undergrad programs.
I do feel as though each of you are talking past each other as to what divert means. Divert where, I think, is the issue. Divert to St. Mary's art program or divert back to the endowment for the oil and gas. And I think that's where you're speaking past each other.
Okay, well, our position is based on the gift instruments. It can only be used as supplemental salary for the chair of the Castleberry chair, which teaches oil and gas. I mean,
we just, that's not all of the permissible purposes under the gift instruments. They've acknowledged that there are others. And I think if they frame it in terms of the gift instruments, my point to the court would respectfully, St. Mary's is not in here taking a position that it can use the Castleberry endowment funds for purposes other than those contemplated in the gift instruments. If they would like to seek some confirmation of that through discovery or otherwise, then they'll get it as soon as they ask for it that way from us. But
Fair enough. That's enough of a dead horse there. All right. Any others each of you wish to speak to?
no, Your Honor, we appreciate your time.
You got me for about 4 more minutes, so
I appreciate your patience, Judge.
No. This is good. I'm not. I have some fairly significant inclinations on how I'm going to rule on this. I never rule on summary judgments at the spur of the moment. I'm going to, unless there's some form of emergency or a pending hearing that it's relevant to immediately. So give me a couple of weeks. I'll have an order for you. I agree in part and I disagree in part for both of your positions. So it'll be an interesting order. But before I do hang up, anything further for anyone else?
Nothing from the defendant. Thank you. Appreciate the court's time today. Thank you.
No, I think it's very important. I think it's very important issues for all around. Okay, give me some time to digest it. And by the way, believe it or not, you can see the mess over here. I have gone through all this. So I do see some merit in both of your arguments, but I also see I also see a few that I may agree in part with a couple of your summary judgment motions, but not agree in totality. And that statement applies to both of you. So I'll just craft an order that I think best suits what I believe should happen. Okay.
Thank you.
All right.
Thank you, Your Honor.
The court stands in recess. We're off the record before we all hang up. I do want to thank you. I hope, and I always end every hearing in the same manner. I hope the court has provided you with a fair and respectful forum. I promise you I will give this the thought necessary to put out an order. All right.
Merry Christmas, Your Honor, and a vaccinated New Year.
Eat to your heart's content, but not your stomach's discontent. So.
Hey, Newman, if you'll shave, I'll shave.
Not happening.
I'll be done. Next time you see me, I'll be clean shaven.
Dan,
You're talking about the top of your head or your face?
Well, that's gone a long time.
Dan, I do have to say to your credit, you really did speak a lot less than Bob.
I told you I would.
It was a dare, Your Honor.
All right, guys. Give me a couple of weeks. Like I said, for unless you feel some reason that I need to rule right away, for very personal reasons, we're off the record that I shared with you off the record. This next 2 weeks is going to be pretty significant within my family. I think I told you my brother-in-law passed. My father-in-law just got out of COVID and he's not doing well. So we've got to fly up there that's where everybody's at, to take care of both my sister-in-law, drive, both my sister-in-law and my mother-in-law until they can kind of get through this dark moment. And I have to drive right back. My dad's going through pretty intensive pancreas surgery. They're going to cut out half his pancreas. And I hate to be so public with this, but between us. So I hope you'll forgive me if it takes me a few weeks to get the order to you.
Your Honor, I would hope that Mr. Johnson and our team could agree that we just sort of stand down through the end of the year, if that's at all possible. That way we don't wind up for any particular reason before the court.
Yeah, if you guys can come to that agreement, that would be lovely. In either case, I'm not going to be to hear it. I'm not going to be here to hear it. So, yes, you guys can yell at each other all you want. You have no referee. So, okay.
Thank you, Judge.
God bless you. Have a Merry Christmas and a Happy New Year.
Thank you, Your Honor.
Your Honor.